But first of all, I just wanted to say thank you to everyone that's joining us for our State of the Executive Orders. And a big thank you to Ali Mitropoulos, who's the immediate past president of, and what do you call the Women's Bar of Massachusetts, Ali?
The Women's Bar Association of Massachusetts.
Okay, great. Perfect. Nice and easy. Um, and obviously, over the past year, we've had several executive orders come down, and Sheila did a presentation. Sheila Abrams here as well, and she's going to be our moderator until her flight takes off, because we have her for a limited period of time. But she had also presented on some executive orders, specifically affecting bar organizations, and it was really fascinating and eye-opening. And I know that our National Conference of Women's Bar has leaned into the Women's Bar of Massachusetts as a, real, I guess, leader in this space in terms of like condensing and filing this information, really truncating all the information and getting it out to your members. So I wanted to lean into that and have you present today for the rest of us. So thank you very much. And with that, I'll leave it to Ali and Sheila.
Thanks, everyone. Sheila, feel free. I know you have a lot of experience in this, so feel free to hop in if I'm missing anything or if you've got any additional thoughts as well.
Of course.
And anyone else on the call too, if you have any questions, feel free to ask any questions or go through. But I thought basically what I do is kind of talk kind of at a high level about the executive orders that we're seeing and specifically the ones that may impact bar organizations. Um, there's obviously as depending on whether or not you accept federal funding as a bar organization, I don't think many do. You're going to have varying levels of impact, but they are obviously some impactful uh, executive orders to specifically that direct to bar organizations. And then kind of on the women's bar front, um, talking also about when to make statements about, certain executive orders or other kind of federal actions that are taking place, given the landscape that we're in. What the kind of impact that might be, what to consider when you're making statements, and then kind of thinking through as an organization, and something that we have talked a lot about as a bar association is, when an issue is political and it's kind of more political speech, versus when an issue is really a women's issue that does really fall into our mission, but has been politicized. So, like the primary example, I think, is, for example, abortion laws and regulations. It's a very politicized issue, but at base, it's a women's health issue. So, when to make statements on what and what impact that might be. Obviously, I come from Massachusetts, so our state is, fairly liberal in most spaces. And we have a very liberal governor and a very liberal attorney general who have been fairly outspoken themselves about things. And so if you're coming from a different state, obviously you're that's the calculus is going to be different than for the WBA of Massachusetts. Um, but all part of kind of considerations. So again, please feel free to jump in at any time if you've got kind of additional thoughts, if you have different ways that you're thinking about it for your organization, or you just want to chime in with a question or a comment.
So, Allie, one thing I might
Yeah,
add for the general discussion for consideration here is also potential funding, right? So,
yeah,
when you think about what your sponsorships or your donors or how you're getting your funding, recognizing that shifts in how people are either directly perceiving women's bar associations or are if they're a firm or some kind of entity that, does receive federal funds and may be limited in the types of things that they can support, that is a worthy endeavor for you as an organization to be thinking about and looking through from a budgeting standpoint and a forecasting standpoint.
absolutely. No, that's super important. All right, so kind of thinking about executive orders more broadly, they've obviously, from kind of the very beginning of the Trump administration, starting in January, have become a primary mechanism for kind of policy shifts without, necessarily always going through the full notice and comment period. Executive orders have obviously always been a way for the executive branch to provide their thoughts on the way that the policy should be going. Um, but they have I think we've seen that's a little bit different in this administration is that they've been increasingly using executive orders to address issues related to civil rights, higher education, DEI, reproductive health, immigration, workplace regulations, kind of everything under the sun. Um, while most of the executive orders don't regulate bar associations specifically, there are obviously downstream legal effects. And we did want to flag one specific executive order, which was put out in kind of the very beginning of the Trump administration at the end of January, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunities. That executive order did a couple of things, three primary ones. One, it stated that all executive departments and so all federal government agencies were ordered to terminate all of their discriminatory and any what they call discriminatory and illegal preferences, mandates, and policies, but really all DEI programs. Second, it asked federal contractors, so anybody who, is considered a federal contractor, to do the same. And then third, it encouraged the private industry to do the same as well, and requested each agency to go out and kind of investigate any I think they set up to nine basically individuals or companies or areas that might be violating this kind of new policy set forth in the executive order. What was interesting about this executive order is that it also specifically called out both bar associations and medical associations and said, you're one of you guys are also on the hook for this, and we're also looking at you. So what we saw kind of following that was that the federal agencies all removed their DEI resources, launching pages, anything that they had resource wise. Um, and, I think we did see a couple of the larger bar associations across the country really start to consider whether, their DEI CLEs, DEI materials might come underway. And so, I know we had a lot of conversations with the Massachusetts Bar Association, the Boston Bar Associations, other kind of the larger bar associations in our Commonwealth to determine, are you guys making changes? Are you not? We all kind of as uh, the three kind of largest bar organizations in the state all decided to come together and say, no, we're not making changes. But again, and I'll get into this as we discuss kind of the decision making around making statements and who you're collaborating on statements with, what that process kind of looked like. The other area that I think we're seeing might have potential impact on bar associations is in the kind of IRS 501(c)(3) C6 space. So our association, as I think with many of you all, is a 501(c)(6), so it's a membership organization. We do have a foundation, a sister foundation, the Women's Bar Foundation. That is kind of attached to us, but is a separate legal entity, and they're the 501(c)(3) of our sisterhood. Um, the IRS um, has specifically stated in their kind of new policy guidance that they intend to look at 501(c)(3) status. In that policy guidance, they were talking specifically about schools, and I think really private K-12 schools is what they're kind of getting at. In addition to higher education, which they're always threatening to be rid of our 501(c)(3) status. But it is an interesting turning point because they linked it specifically to this executive order, saying, are you following the DEI mandates of these executive orders? So as we're kind of seeing the door open by the IRS, and again, this was just kind of a, hey, here's what we're going to do policy wise in this next year. And again, when we were in West Virginia, Sheila did a great talk about this. We that that guidance from the IRS is really opening the door for interpretation, or what we can interpret and what we've talked about at our board level is, does this mean that if we continue to do this programming, we could potentially lose our C6 status? Um, what would that mean for us? What does that look like if we can't have our C6 status? Again, I think it's much more impactful if you lose your C3 status. Um, but obviously, the tax implications, and especially if you're a smaller bar organization, would be heavily impactful. So that's kind of on the executive orders that impact bar associations more broadly. There obviously have been a number of executive orders that we as a bar association have decided to kind of speak up about. Um, the kind of first one and we had, this was when I was still president of the association at the time, and we did end up putting out a statement on it, was the executive order defending women from gender ideology, extremism, and restoring biological truth to the federal government, where basically we felt that there's a lot going on. And again, I'm going to talk about this in a second when you're thinking about what are you speaking and when are you speaking. But that executive order specifically, which basically said that the executive branch was going to enforce all sex protective laws to promote the reality that there are only two genders, male and female, and sex refers to an individual's immutable biological classification as either male or female. There is no, and they basically got rid of the concept of gender ideology. Um, so they also talked about in this executive order that federal funds cannot be used to promote gender ideology, that each agency within the federal government needs to assess grant conditions and grantee preferences to ensure that grant funds do not promote gender ideology. I'm going to talk about that more in a second. Um, and that the Attorney General was asked to issue guidance to ensure that the freedom to express the binary nature of sex and the right to single sex spaces in workplaces and federally funded entities. Again, that's really getting at kind of your gender inclusive bathroom spaces. And we're also seeing it kind of played out in the athletic context now, especially in colleges and universities, but also at the K-12 level with really trans women athletes. So I think in terms of, again, the impact on bar associations, one, if your organization gets any type of federal grant funding to do, for example, research or um, surveys of either your organization within your state, or you're part of an organization that may be doing that, you're partnering, or you're kind of maybe a partner to an organization that's doing this type of research, you would kind of fall under the scope of this executive order. Um, in terms of deciding to make a statement about it, and we can get into kind of that part of the discussion now. Um, what we looked to, and we have a framework in place at the Women's Bar Association of Massachusetts on how we decide to make statements and who's authorized to speak on behalf of the organization. When is it kind of like official organization speech versus, an individual just who, is within the organization that's kind of making the statement. But the way that we look at it is kind of in a, six part framework, I want to say, or test. So first we look at like the mission and the nexus to the organization. So does the issue, or does the like whatever it is that happened directly implicate our organization's mission? With a lot of these things, it's not that difficult. It's like sometimes it'll be there's a state law that's been proposed that we think will directly negatively impact women in the Commonwealth. So we'll make a statement either for or against it, depending on, which direction it's going. Um, Other times it's a little bit more complicated. So, on our mission is to promote and support women attorneys and to, but also more broadly, to support um, the the fact that women should be equal in a just society within the Commonwealth. So, does what's being said or does the action impact kind of our core mission? We also take a look at whether or not there's going to be kind of a like an IRS issue. Does kind of getting into the realm of too far political speech, go too far in terms of our 501(c)(6) limits? Um, we look at, and this was kind of more recently, we look at kind of the exposure. What will the are we going to come across issues with our partners who may be supporting the bill? Are we going to come into issues with the Attorney General's office in our state by making such a statement, or is the Attorney General making kind of similar statements? Um, we also look at whether, um, the impact on our members. So like, is this the kind of thing that our members are expecting us to speak on? Is this something that if we stay silent, and is our silence going to be kind of louder than even the words that we're saying? And are we creating a space? Are we making sure that we're creating a space where our members feel like they are seen and heard and represented by our organization? That's kind of a big one for us. We look at it in terms of, really trying to frame things as nonpartisan as possible, even if it's a partisan issue. Again, part of that framing really does go back to that number one, the mission piece of it. How is this impacting our mission? How is this impacting women in the Commonwealth? And how can we talk about it in that way? Um, and then finally, we just make sure that, we're getting it out to everybody in a timely manner, that we're not waiting too long, because that's the other part of it is we feel really strongly that if, you kind of wait too long on statements, it may be an issue. Um, so those are kind of the things we talked about when we did end up making the statement on that executive order. We really focused our statement on the impact, that the negative impact that this kind of policy would have on women, and especially trans women in the Commonwealth of Massachusetts, what it would mean for kind of women generally to have this kind of, language out there and policies and federal policies out there, and really rooted our statement in that. So while we were technically, I guess, coming out against, the federal government and President Trump specifically, we really rooted it in our, this is why we think that this is an issue for women in the Commonwealth, and this is why we don't think that this should be the case. So that's kind of the main pieces that we talked about. Um, We also, as an organization, I'll just note, in Massachusetts do a lot of advocacy work. So a big part of what we do is we have a very active um, uh, committee that looks at all the kind of policies, laws, different issues that are coming in and out of our state legislature. And we have um, a kind of issues list that we release to all of our members saying, hey, these are the bills that we're supporting. These are the bills that we're opposed to. Here's why. We do a lot of work in that space. And we also at the same time separately have a very active amicus committee that does the same thing, is looking at, where are we signing on to amicus briefs, what amicus briefs are we writing and are asking others to sign off on. And kind of as part of my presidency, and I know others who have been president of the WBA of Massachusetts as well, one of the things that we talked a lot about was how do we make sure that we that we're representing all of the voices, but also that the the WBA of Massachusetts, like when there's a women's issue or when there's an issue related to women, that we are the first call. Like I don't want the Boston Globe or the New York Times or Mass Lawyers Weekly or whoever calling like the Mass Bar Association or the Boston Bar Association for their comment. Like they should be calling us. And there are issues that we need to be. And so, kind of again, on the decision making of when do we speak, the importance of speaking when there is truly a women's issue at hand and being right on the forefront and getting, we've gotten others to sign off on our statements, but this was, one of the things that I worked really hard on during my presidency was to talk to the other bar associations and not to tell them like, to back off, but essentially like, hey, we're going to take lead on these issues. I want your sign off because I want it to be from the Women's Bar Association, co-signed by, the Mass Bar Association, the Boston Bar Association, the Worcester Bar Association, all kinds of major bar associations, but we're the lead voice here. And on other issues that like you guys take the lead on, we'll co-sign as well. But I want to be the lead voice because this is the core of our organization. Yeah, not that we're trying to, exclude others from speaking. We just want to be the primary voice because we think it's important. Um, and that's a big piece of kind of our decision making in when we talk. I don't know if anybody has any questions, comments, concerns. I feel like I'm talking a lot.
Oh no, it's great. It's great. I did have one. I was wondering on the legal discrimination executive order that you talked about in January. Sheila, I feel as though you had talked about a couple cases that you felt like stemmed out of, that particular executive order and people sort of taking one side or another, in terms of, okay, well, this is what we think it says. And you had talked about a couple cases. I believe one might have even been involving education, and I think one was another at a workplace. But I was wondering if you could speak to those cases and sort of how they were interpreting that executive order.
Yeah, absolutely. And Allie, I know you do some higher ed work, so
Mhm.
feel free to jump in too. But one of the things that we're seeing, especially in the higher education space, which directly impacts our Women's Bar Association pipelines, as well as the potential membership, if you have those types of, you do have law student members, relates to kind of the Students for Fair Admissions case, and that was I guess it came back out in 2023 that we talked about the use of race in higher education admission standards. And the Department of Education has come out earlier this year and really said that their interpretation of student fair admission is that it applies to all aspects of the educational experience on a higher education campus. And that also means, of course, that if those entities are receiving federal financial funds, um, they are adhering to the executive orders and the Department of Education's kind of interpretation in that regard. And so, when you think about how that may impact, again, pipeline or your membership base, that is something to be thinking about and have an awareness of what your, before law school, especially those that are likely public and receiving federal funds, what that means in terms of their participation ability as well as their sponsorship. I do apologize, guys. I'm boarded a plane on that. The other thing to be thinking about is we're starting now to see some of the cases coming out of the um, from the era of 2017, 2018, 2019, 2020, when there was a huge and kind of heavy focus, if y'all remember, and harken back to that time on like Black Lives Matter and some of those other kinds of topics and whatnot. We're starting to see those cases where people have brought some employment discrimination type cases or claims filtering through our court system around at the same time we're getting these kind of executive orders. So seeing how that information is being interpreted and used and what people are understanding of that, I think it's something as a Women's Bar Association we have to have a special pulse on, especially because for all the reasons that Alan has already talked about, but we all are employees or we're all employers at workplaces. And so actually having an understanding of that is really important.
Yeah, those are great points, Sheila, and I think those cases are really, beginning to illuminate what we can kind of expect going forward as well. And I think especially, I think your point especially on those recipients of federal funds that we often work with, like law schools, is a really good one because, um, as Sheila just mentioned, you got this student for fair admissions case that came in. Again, it was like solely related to admissions in higher education, but it's been kind of built up more and more. We did see that Department of Education guidance out in February. We now have Department of Justice guidance that came down at the end of July that says essentially the same thing. There are, you can no longer do certain things in the DEI space, including, you know, they specifically talk about kind of mentorship and other kind of programmings that's specific to either one gender or one race. They're really talking about it in the race context, but but gender is also mentioned in the DOJ memo as well. And so, part of what that kind of initial Department of Ed guidance said, which has but separately since been struck down by a federal court, but is still what the Department of Education thinks, and that's kind of what matters, um, is that it's not just are you doing this on your campus, it's are you partnering with other people who are doing this. It's not just limited to what's happening on your campus. It also includes third parties that you may be contracting with or working with that would like kind of bring this to campus. So, when you're thinking about going to different campuses and doing mentorship programs or doing um, uh, specific networking with either their women's group to the extent that they still have them, which a lot of them do. Just making sure that whatever language you're using to promote it is clear that everybody is invited and everybody can participate. It's not solely limited to women or solely limited to one race. That I think is really important. And we have done a lot of work kind of with our law school and undergraduate program partners to make sure that we're not somehow getting them in trouble, like even because it would be the school that gets in trouble rather than really us, though, who knows if they decide to go after us too. But we have been looking at that in terms of how do we make sure that our language is clear, that that's open and available to everybody, and that we're not, even though we are the Women's Bar Association of Massachusetts, anybody can get mentorship advice from us, no matter what gender they are. Um, I do think that it's a really interesting space to work in, and it's, one that as a GC at an institution we've been struggling with is how do you continue to create these really important spaces for people, because we know, and just talking about the women context, um for purposes of this, like it's really important to have women's spaces where people can come together and talk about their similar experiences, and to talk with mentors. That's like a lot of the basis for why our organizations were started, was because there needed to be there was a need for these spaces to be able to come together and gather and have just shared experiences together that other people who you know, may not have. And I think that that was really, we're losing a little bit of that with this administration because everything has to be open to everybody and equal to everybody, which has always been the law, as Sheila can attest to. The Title VI always said, and Title IX in the education context always said that it has to always be open to everybody. You can never exclude. This isn't new. But I think there was just more leniency on what does that look like? And I mean, according to the Department of Justice, you have these kind of proxy spaces now. And what do those, what is really open to everybody versus what is just a proxy for something else. And you look at anything and it can be determined to be a proxy. But it is, I think, another kind of important point, to just make sure you're relooking at your programs and making sure that if you are working with somebody who's getting federal funds, that you're not accidentally exposing them in some way.
Yeah,
Well,
to the
intimidated
point.
part. Yeah.
Yeah, in actuality, I'm in Colorado, and so the Colorado Women's Bar is looking to host, speaking of mentorship, a
Mhm.
specific program that's like a three-part mentorship program And it was specifically meant to be allyship. And so obviously it's open to everyone, but the initial name that they had chosen for this program, specifically had DEI in the title. And it based on what I knew, right, from our National Conference of Women's Bar and sort of the advice that I had been given as well was even if that's what we're doing at our base and we're still trying to, you know, create spaces that are, I guess, facilitating DEI at its foundation, that the changing of the title is exactly what you want to be doing, right? And enough to, great, yes, but it also doesn't necessarily mean that as an organization, right, we'd be shying away from doing DEI. And I guess the education piece of even all of our members is necessary because I reached out to a gal that was running that program to say, this is great. Let's just tweak the title in this way. I think that's a good idea. And they thought it was coming from the law firm that was hosting it and said, I don't think we want to be connected to this law firm anymore if they're not going to be supportive of these efforts. And I said, no, that's not it at all, right? It's that that particular law firm is very involved in lobbying, and they have, an entire arm that's sort of in that realm. And we don't really know, like you said, to your point, like where else they might have endeavors. And it just is almost important for us to look out for them so that we're being, a conscious partner.
Totally agreed. Totally agreed. And and it is, I think that there's a real place for women's bar associations, especially to kind of step up now and participate in those spaces. Because I do think it is harder for institutions, to be as open about these conversations. So even if we're even if we're hosting it kind of not in necessarily even in collaboration with those other people, but hosting it on our own and making sure that all of those people get access to our programming, we're kind of a space where they can come, obviously while keeping in mind all of the stuff that we talked about at first about the 501(c)(6) status and the administration possibly coming after people. But just making sure that we're watching that we are that to the extent that we can create the space and for them that we can do that, and that's I think a real value add for women's bar associations. That being said, I don't know, and Sheila, maybe you know more than I do. I don't know. I don't think that any bar associations have been directly attacked yet or gone after yet. I know that obviously we saw the kind of the law firms being directly attacked, not always specifically for the DEI space, though many of the settlements that they agreed to included DEI related language, as we're seeing now, kind of in the same vein with the settlements that the Trump administration is entering into with, the few colleges that we've seen. Um, so, but I think it will be interesting in telling if the IRS or another agency does decide to go after a bar association, what does that look like kind of from a federal perspective?
So you raised two really good points. So A, there has not been any direct action so far to bar associations, but it brings about this idea, especially as we go down by being 2020 or whatnot, it being November, of like a uh, preemptive compliance thought and concept of like the mindset that an organization may have had in February or March might look very different than what it looks like now. The other thing to be thinking about is that if you are affiliated with a mandatory bar, as part of your organization or you're part of a mandatory bar's umbrella, you have to be especially sensitive to this because mandatory bars also have a level of tax or something or they're going through attacks from a lot of different areas. And I believe like the State Bar of Wisconsin recently was sued based on their DEI initiatives and like their lockout program and whatnot. So it's important to remember and be thoughtful about those pieces too.
Yeah, that's interesting. I know Colorado has a DEI requirement as well for our CLE requirement for the year.
And they haven't changed that. That's super interesting.
Yeah.
Massachusetts luckily has no CLE requirements at all. So we don't so we have plenty of DEI and other CLEs, just it's just not required. Um, but yeah, is there anybody else on the call who has any questions or any how their bars associations have been handling things? And if not, that's okay too. Okay, be safe, Sheila. All right. Well, I don't want to, Jesse, unless you have anything else, I don't want to keep people for too much longer. I know everybody's busy. Um, but I really appreciate the opportunity to come talk to everyone. And oh, hi, Margaret. Margaret Chalmers is the executive director of the Women's Bar Association. We love Margaret Chalmers. She's the best in the whole world, and everybody should have an
Allie.
executive director like Margaret.
Very kind, very kind. Well, I'm sure you've heard Allie is quite a dynamo. And yeah, I wanted to zoom in earlier, but I had a pre-existing conflict.
No, no worries. But yeah, anyways, I really appreciate the time. And as always, the Women's Bar Association is always, here if you guys have questions or you guys want to reach out um, on any specific questions. We have done a lot of thinking and talking about kind of our bar association speech when we put out statements, what statements we put out, um, and and then on kind of the executive order side too, which ones are gonna both impact the association directly and which impact kind of our constituents and when we need to talk about them. So anytime, feel free to reach out to us. And Jesse, thanks for the opportunity to chat about this.
Yeah. Yeah.